Item D, adopt resolution opposing state actions and directing city manager to cooperate with the League of California Cities and the California Redevelopment Association in litigation challenging seizure of city and agency funds. Director O'Leary.
Mr. Mayor, members of the City Council, at the last meeting in July, the city manager and I briefed the council on both the state budget and the impact that the state budget, as it was approved by the legislature and signed by the governor, would impact cities, including San Bruno. The information that was provided to you at the time has borne out over the last month to be highly accurate, unfortunately, as far as there being some significant impacts on both cities and redevelopment agencies in California. At that time, a month ago, was mentioned that there are really two impacts foreseen on San Bruno. The first impact is a borrowing by the state of city property tax funds that is anticipated to amount to about $829,600 will be borrowed from the city in 9-10 for a period of 3 years. In addition to that, the redevelopment agency is anticipating a loss, and this would not be a borrowing but merely a taking, of just under $2 million, $1,989,000. In looking at the property tax, and I think have to admit that the state has taken actions to probably minimize this borrowing, and in part this is because of the actions of the League of California Cities and the actions of all cities with the passage of Proposition 1A a number of years ago that did in fact put limitations on funds that the state could take from cities. So the legislature anticipates taking about 8% of the property tax from each of the cities, and what the slide here shows is amounts that we have received in 08-09 and the amounts that were budgeted for 9-10, both for property tax accounts, which include secured and unsecured, but the way the State Department of Finance is defining property tax, it also includes the sales tax in lieu monies and the VLF in lieus. In our books, when we record sales tax and VLF in lieu, even though it comes in the form of property tax, we actually record that as sales tax because that's what it is. And VLF, we record the in lieu as VLF, and that's the proper accounting for that. It was actually accounting white paper that says that's the way that's to be shown on a city's books. However, the state is saying, well, it's coming to you in the form of property tax, so it's being part of the base for the 8% calculation. So the intent of the state is on the two payments of property tax that we receive in December and that we receive in April, about $415,000 will be retained by the county and ultimately by the state of that property tax payment. The legislature, when they did approve the budget and the trailer bills that came after the budget, have set up a program that would allow what is being called a, for some reason I always want to say the wrong word here, the securitization program that would actually allow through a third party agency that is really affiliated with the League of California Cities and the Association of Counties, California Communities. California Communities will actually is setting up a program that would allow bonds to be issued, sort of like revenue anticipation notes, that would bonds would be issued that would allow the amount of monies the cities are to receive actually receive that money from the proceeds of these bonds, and then the bonds would be paid back through the repayment that the state would be making, and rather than repaying us if we participated in that program, the repayment would be made to the bondholders. So there's a program that is evolving that would, in a roundabout way, allow us to get what they're projecting to be 100% of our money actually ahead of schedule. We would get it by the end of November if this process worked, rather than the two payments in December and April. It is that is still being developed, and the action of the resolution is both to have the council on record opposing the state takeaways, but also giving direction to the city council that should there be legal challenges to both the property, either the property tax take or the redevelopment, that it would be the position of the city council that the city should be involved and participating in those challenges. At this point, the League of California Cities, to my information, is not pursuing any legal action related to property tax, because if this securitization program works, there's really no loss to the city. But that, again, will be forthcoming probably in the next month. There would be an action the city council would be required to take probably before the end of October if the city wanted to participate in that program and receive the funds through this bonding. If you recall, in the budget discussions earlier, not knowing exactly what the state would do, there was discussion that since it was a borrowing, that an option for the council would be to take these funds that we're losing, the $829,000, out of one-time reserves, and with the anticipation that that money would earn interest and be repaid at the end of 3 years. So that remains an option to the council, but at this point it may not be necessary. Just very briefly, again, for the redevelopment agency, not a borrowing but an actual taking of $1.9 million. Wanted to, this is anticipated by the state that redevelopment agencies will pay this amount due by May of 2010. So it will require ultimately a council appropriation of this money that would allow us to, in fact, transfer this money and to pay it from the state, or to the state. Did want to just point out what you have in front of you is really the 9/10 revenue and expenditure budget for the redevelopment agency operations. The loss, or the $1.9 million, is actually being calculated on tax increment that the city received in 06-07, but it is on the gross revenue that we're receiving prior to any low and moderate income housing calculation. But the payment needs to come out of the redevelopment operations. You can't use any housing money. If you did, you'd have to pay it back. If you didn't pay it back, there would actually be a death penalty for the agency. So it can't come out of housing. But what I wanted to point out in looking at the redevelopment agency budget for this year, you can see that $1.1 million goes directly to operations. Our obligation for pass-through payments, including basic aid, is $2.9 million. Our debt service for the Police Plaza is $648,000. The interest payment to the general fund is $200,000. Transfer to capital projects in this year's budget is $100,000. If the state, and when the state takes $1.9 million away, this year the redevelopment agency will be in a deficit of $41,000. So it is not looking at this year and saying that the state is taking excess money or free money. In fact, their taking will, for this year, put the redevelopment agency in a deficit. So it is a significant take as the agency is considering the implementation and the final transit corridor plan and some of the interests that the council has, potentially even around grade separation or the vision. This is a significant taking from the city, and that is in fact subject of legal action. Just point out very briefly, a similar taking by the state in 08-09, or a similar attempt by the state was found unconstitutional by a Sacramento Superior Court. The state changed the wording slightly and is directing the money towards schools in the redevelopment in the redevelopment area. I mean, that's a pretty flimsy restructuring in order to get directly around the court ruling. So the California Redevelopment Association is pursuing and gearing up for legal action against the state that this is clearly an unconstitutional taking, and that is something that I believe will proceed.
Through the chair, just so I'm clear, the tax money they're taking will be in fact repaid one way or another within 3 years.
No.
The property tax.
The property
is
tax.
A borrowing. That's
right.
Correct.
That's a borrowing, right, from an entity that doesn't have it to borrow to lend. But this redevelopment, that's gone.
That's gone. The anticipation is this year they would take $1.7 billion from agencies, and next year they would take $350 million from agencies. It would be my personal view that if they get away with taking 1.7 this year, that 350 million next year will be a much bigger number. So the significance of this is not a one-time event, and so the long-term impact on redevelopment agencies has the potential to be significant.
Just to add briefly to what the Administrative Services Director has articulated tonight, we're asking for your continuing authority, as I believe that we have perceived or received it in the past, to continue our efforts to engage with the League of California Cities as well as the California Redevelopment Association to stay vigilant as a matter of policy, that these kinds of raids on basic city resources are completely unacceptable. And we would continue to advocate that, again, in coordination with the legal actions that are anticipated through the California Redevelopment Association, as well as any continuing advocacy at the League of California Cities. That said, as the Administrative Services Director has articulated, we anticipate that this type of action will continue, and I think we have kind of a double-edged sword situation in that the state has demonstrated, in my opinion, its clear inability to address its own budget situation. And while the state legislature and the governor have found a deal to sign off on, it is by no means a solution to the state's much more serious budget challenges. So on the one hand, this occurring presumes or anticipates that it will continue next year. On the other hand, if the litigation by the CRA is in fact successful and the state is precluded from taking the redevelopment resources, we should not kid ourselves. They have no alternative. There is no plan B in order to take care of the state's continuing serious budget problem. So I guess that's meant only as a word of caution and a reality check that this is an issue that is going to continue to challenge us and other cities up and down the state into the future. The Administrative Services Director mentioned that in the slide that you have in front of you, and I just wanted to note, if nothing else then for public information, that we make a very substantial subvention or pass-through payment of redevelopment tax increment resources that at least initially come to the city via redevelopment law and the establishment of our redevelopment agency. The $2.9 million is not only a big number, but as Jim indicated a moment ago, it includes not only pass-throughs that are made on a formulatic basis to all of the taxing entities within that would otherwise receive taxes, property taxes within the redevelopment project area. And of that amount, a significant amount is schools. In our case, just over $1 million of the total $1.9 million in basic pass-throughs goes to schools. Just over half of the amount that is passed through, initially passed through. The $2.9 million number that you see here also includes additional payments to basic aid school districts in the total amount of $1.4 million. So because of the circumstances of the financial structure, which our redevelopment agency and we have no jurisdiction over, those school districts, and there are two of them, San Mateo High School District and the Junior College District, both are basic aid school districts, and they receive additional property tax increment because, in fact, they do not receive other normal school funding from the property tax is considered to be sufficient enough in their jurisdictions that the state does not make other payments. So in essence, we're tasked with making those payments via our redevelopment agency. So there's a very healthy amount of this already going to schools, and now the take of $1.7 billion by the state is going to take care of the state's obligation, or assist in taking care of the state's obligation to schools. So I wanted there to be no mistake that the city and its redevelopment agency does not have that independent obligation to schools. This is a state obligation, and any obligation that we have is already well addressed by the sharing of property tax and the distribution of redevelopment property tax increment. So with that, we'll stop.
Any questions of staff? It's as bleak a news as you could bring forward, but I guess the silver lining is our budget is balanced, and it's a real balancing. We haven't borrowed money that we don't even know that we can borrow, or money that we don't know that we can take. It will be there and will be balanced, and next year, the more the state takes, the more that budget diminishes, but we'll still be balanced because we're mandated to do that.
Plus I'd like to add that I wouldn't have it any other way than to have redevelopment. And as much as it's a big pile of money that the state is taking, redevelopment has been a very good thing for the city of San Bruno. And it's just unfortunate that right when we're primed to be able to use redevelopment money that we're getting hit.
The chair will introduce the resolution.
Okay. Roll call, please.
Vice Mayor Ruane.
Aye.
Councilmember Medina.
Aye.
Councilmember Ibarra.
Aye.
Councilmember O'Connell.
Aye.
Mayor Franzella.
Aye.